Most people think their entitlements in a separation depend only on what they put in. Who owed the money? Who paid the mortgage? Who covered the bills? But here's the real twist. The law isn't just about the past, it's also about the future. We helped a mother of 3 who hadn't worked in years. She was worried she'd lose out because her husband earned all the income, but her role as the children's primary carer, combined with her lower future earning capacity, meant she was entitled to a larger share. I'm Hayder Shakara, Director of Collective Family Law Group, and in this video, I'll guide you through how entitlements are assessed, what factors really matter, and how to avoid the mistakes people make when they're separating, using real examples from cases we've worked on. The first step is working out what's in the pool. This includes homes, investments, superannuation, businesses, trusts, even debts. This might sound simple, but sometimes this is the hardest part of the exercise, trying to figure out what exactly is in the asset pool and what is the value of everything. We had one client who thought she had no entitlement to the home because it was in her husband's name, but the home was purchased during the marriage and used for the family, so it was absolutely part of the pool. In another case, a husband had a discretionary family trust he assumed was untouchable, and because he controlled it and used it for family expenses, we argued it was effectively part of the asset pool, and that made a 6-figure difference in the final settlement. After we figure out what's in the pool, we then start to assess contributions to the pool. Maybe you've been making financial contributions, maybe you've been making non-financial contributions, maybe you've been doing both. For example, one of our clients had been the breadwinner for a decade while her partner raised the kids and managed the home. She thought she was going to end up with a large chunk of the asset pool because her partner didn't earn any of the income. But we explained that homemaker and parenting contributions are recognized and just as valuable. In her case, the court viewed both sides' contributions as equal. In another matter, we represented a husband who had invested a $500,000 inheritance into the family home early in the marriage. His wife argued it was for the family, so it shouldn't count in his favor, but we successfully argued that the contribution should be weighted, which shifted the division by an extra 10% in his favor. After you've looked at the contributions, you then have to look at the future needs of both parties, and this is where outcomes really start to shift. We once helped a mother of 3 young children. She had been out of the workforce for years and had limited super. Her ex-partner was healthy, earning a 6-figure salary, and had a far greater earning capacity. Even though their contributions were similar, she was awarded a higher percentage to account for her future needs. On the flip side, we acted for a man with a disability. His ex-partner argued for a 50-50 split, but because his health limited his earning capacity, we were able to secure him a larger share. The key takeaway here is that the courts don't just look at what's happened in the past, it's also going to look at what each party needs into the future. When people are asking what they're entitled to in a separation, they often forget about superannuation. People don't realize that super is included. We've had cases where one party has had 3 times the super of the other party, and a super split has been ordered in order to balance it out so both parties are able to enjoy their retirement. Also, another huge one, don't assume debts in one person's name are theirs alone. We've seen clients shocked when family loans or credit card debts were treated as joint. Yes, even all of those extra expenses that your partner is incurring, they could be shared by you if you are in a separation. So if you're asking yourself, what am I entitled to? Here's what to do. Gather your financial documents, bank accounts, super balances, property valuations, and put it all into a spreadsheet so that you can take stock as to what exactly we're talking about and what the values of each item are. Once you have that, you need to figure out what you both contributed to the asset pool. Don't assume it's automatically 50-50, but try and negotiate a settlement so that you can finalize it without going to court. We find that over 90% of our clients settle without going to a trial, which is great news because you save on legal fees. But if your case is complex, it involves hidden assets, trusts, complex businesses, or big disputes, you're going to need a lawyer to help navigate it. At our family law firm, we've guided thousands of Australians through this process, whether it's simple, amicable settlements or complex disputes involving businesses, trusts, and hidden assets. Our website is more than just a firm profile. It's a knowledge base filled with free resources to help you understand your rights. And we don't just say we're good, we've built a library of reviews from clients we've helped. Because in family law, it's not about what we claim, it's about the results and it's about the evidence and all of the trust that our clients put in us. Like and follow for more updates, reach out to us if you need any assistance, and please subscribe to our channel if you found this video useful.